Hello, everyone, and welcome to the fourth DanubeDNA webinar. We will talk about regulation, ethics, and the responsible use of AI. Now, the ethics and responsible use of AI will be weaved in through the regulation because that is something that is coming and something that is already here. So, first disclaimer, I am not a lawyer. I have just used AI for a really long time. This is my reading of the current technical and legal situation. None of this is legal advice, so please consult your lawyer. The thing is that the framework we will be talking about is new and evolving, and it is being actively amended. So first, something about me. Who am I? I am an assistant professor at the University of Osijek, Faculty of Electrical Engineering, Computer Science, and Information Technology. Through my academic work, I have been involved in many AI research projects, and currently I am the principal investigator on 4 EU-funded ones. The first is SEAM, where we will be building an AI system for self-consumption solar installations. Abacus is an AI-boosted agricultural news publishing platform. eScience and Dentilligence are just starting now, and they focus on agentic AI for business process automation and AI methods for the dental industry. Other than that, I have extensive industry experience. I was a co-founder and lead DevOps in a digital agency for around 10 years, and now I am the founder and CEO of an AI consulting company. So I read the legal landscape because I have to operate inside it. I am not a lawyer, so take everything I say through that lens. First, when I said that all these regulations are being actively amended, yesterday there were negotiations between EU institutions around the AI Omnibus. The Omnibus is a package of regulations that will affect many different regulations, and it was introduced especially because of the current situation around implementation timelines. One of the things they will discuss is a shift in some of the dates. So not everything will come into force as quickly as the initial reading suggested. Some of the proposed changes, which are likely to be accepted, are that high-risk applications will probably get around a 1-year extension. What will go into force on August 2nd, or is already in force, because all stakeholders in the negotiations agree on it, is Article 4 of the AI Act, which covers AI literacy. Article 50, which covers transparency, also applies, meaning that you need to label your generative content as AI-generated and similar. And GDPR already applies. Most of you know about GDPR, but now GDPR will probably become even more relevant since AI will make it even more enforceable. So what does this mean for you? The stable items, AI literacy and transparency are something you will need to do regardless. Probably most of you here are not dealing with high-risk applications. We will cover what that means. What will probably be accepted is the deferral, not the cancellation. So high-risk applications will still have to comply, but they will get a little bit more breathing room. The point is that the regulation is being written on the fly, and now they are changing things 3 months before the deadline. At the same time, the rules are constantly shifting. I do not know how many of you know this, but in September last year, Anthropic changed Claude consumer accounts to opt out of training. That means that anything you say to Claude while chatting with it can now be used for training unless you specifically opt out. Previously, there was a 30-day retention period, and they said they would not train on your chats. Now, there is a 5-year retention period with training, and there was no email, no warning. They simply amended their terms of service, and unless you specifically clicked to opt out of this, your chats can now be used for training. So over the previous webinars, you have seen tools that forecast demand, match funding, assess readiness, plan investments, monitor production, inspect wealth, and similar things. Here, we will cover the implications of using and creating such tools. So next, the roadmap. We will cover the foundation, meaning how the law sees AI. We will show 4 realistic cases and how the law sees the tools you use. We will also say something about the deployer's playbook. There is a difference in the regulation between being a provider of a service and being a deployer of an AI service that someone else provides. So we will go through that. And finally, we will go through a checklist of 5 things to do this week. What are the things you need to do now to make compliance with the coming regulations easier? There are 2 regulations that matter most. The first is the AI Act. It is new and it is staggered, which means that different parts are coming into force and enforcement at different times. Some parts are not yet in force. The second is GDPR, which is probably familiar to all of you. It has been enforced since 2018, but now, due to the prevalence of AI applications and AI use, GDPR will probably require more attention from small and medium-sized enterprises than the AI Act itself. So GDPR is the bigger near-term compliance burden, and the AI Act layers on top of it. Now, when we talk about the AI Act, there are 4 risk tiers. First, there is the prohibited tier, which has already been enforced since February 2025. It is defined in Article 5 of the text itself. These are practices that are prohibited in all cases, so they are not high risk and regulated. They are explicitly prohibited except in specific circumstances such as law enforcement and similar cases. Some of the things that are explicitly prohibited are social scoring, so any type of social scoring, emotion recognition in the workplace and in education, and real-time biometric identification in public spaces. What will likely also be added soon, and it is included in the omnibus regulation I mentioned before, is AI-generated non-consensual intimate imagery. So nudes and similar content, which is very prevalent on the web today, will probably be much more strictly enforced. Then we have high-risk applications. High-risk applications are defined in Article 6, and they are listed in Annex the 3rd and Annex the 3rd. Annex I covers AI as a safety component in regulated products, such as machinery, medical devices, vehicles, and similar products. There is a significant documentation and regulatory burden for high-risk applications. High-risk applications defined in Annex 3 are standalone uses in areas such as recruitment, education, credit, worker management, and similar areas. These are the categories we are mostly concerned about, and we do not want to end up in one of those 2 categories. Then we have limited risk. This mostly concerns transparency. So if your application is using generated text or images, mark them as such, and you are mostly in the clear. And then there is minimal risk, which is everything else. There are no specific obligations in that category. When we talk about AI law, the AI Act differentiates between an AI model and an AI system. These are 2 different layers with different rules. A model means the trained weights. So GPT, Claude, Gemini, or whatever is the flavor of the chatbot you are using, those are large, enormously large models that are generative and multi-purpose. Providers of such models have a really high regulatory burden. There is also an option to modify such models or to fine-tune them for your own purpose. Now, that depends on what kind of model you are using. There are really, really large models like the ones mentioned here. The exact text of the law says 10 to the 25th floating point operations for training. For the ballpark, that is around 20 million euros of GPU compute to train such a model. So none of us will probably be in that category. These are generative models with systemic risk. Then we have generative models that are a lot smaller, and it is possible that some enterprise projects will be in that section. For the ballpark, those are around 100 times smaller, 10 to the 23rd floating point operations. Or, in terms of money, you need around 200,000 euros of GPU compute to train such a model. Those are the rules for models. Then we have the AI system. A system can use AI models from a different provider, and that will apply to most of us. Most of us will be using a provider's model, so we will send images, text, or something else to the cloud to do some processing and then return the result that we will show. I believe that many of the tools showcased to you in previous webinars were AI systems that use an AI provider's model. So this is the situation. We are building on top of a model. This is system-level work. We are not modifying the model. And most small and medium-sized enterprises operate exclusively at this level. They never touch the model. Now, there are 3 types of actor roles. First, there is the provider. It can be the provider of a model, or it can be the provider of a system. If possible, you want to be a deployer and not a provider. A provider has a much bigger regulatory burden when it comes to documentation and similar requirements. A provider develops the system and places it on the market. A deployer uses it under its own authority. Now, Article 25 allows the deployer to become a provider if they put their name or trademark on the system, if they make a substantial modification, or if they modify the intended purpose. That is when Article 25 can switch you from a deployer to a provider, which could increase the compliance burden you have for such a system. In their publications and announcements, they confirmed that prompt engineering, retrieval-augmented generation, custom GPTs, and similar things are not model-level modifications. The good thing is that most of the applications you will build or use will be these types of applications, so they avoid those really complicated documentation requirements. Fine-tuning, meaning changing the model weights for your own use, might switch you to the provider of a model. But there is a compute threshold, which is 1/3 of the original training. So even if you took an existing model and tried to update it to be better suited for your own use case, it would still require 1/3 of the original training and compute. That is something like 70,000 euros of GPU time. So that is something most of us will also never hit. The official stance of the new commission is that this threshold is set high on purpose, and they expect very few modifiers to really have to switch to providers, so that is reassuring. Now, if your use case is already high-risk AI, and we will cover what that means in some examples, then fine-tuning on your own data is a different question. When talking about AI, we also have GDPR. These are some of the articles that may not be as problematic from a compliance standpoint in normal applications, but when you introduce AI, they can easily become a bit more serious. So here is the list of articles and what they regulate. Article 5 covers purpose, limitation, and data minimization. This means that you should not ask for more data than you need, and you should not use user data for purposes they did not agree to. Article 6 covers the legal basis for processing. So you need to have consent, a contract, or another valid legal basis to use the data. Article 22 covers the right not to be subject to fully automated decisions. We will cover this a bit more later. Article 208 covers data processing agreements. This is something that will probably become a lot more important in the future, because most of us are using AI applications and AI systems that are hosted in the USA, so data leaves EU territory. Now we need to check data processing agreements with every vendor to see what they guarantee they will or will not do with that data. Next, we have Article 32, which covers security. Then we have Article 35, which covers the data protection impact assessment. When you are using high-risk AI, you need to do this impact assessment to document how the data will be protected in that use. And then we have Articles 44 and onward, and Article 88, which cover international transfers and processing in the employment context. So now, you probably thought we would talk a lot more about the AI Act, but the AI Act is not the thing that will matter the most for small and medium-sized enterprises right now. This morning, I tried to find an update on what they actually agreed on, since the omnibus negotiations were yesterday, but I could not find it in time to update the presentation. What already stands is Article 4, which tells you to learn about AI, Article 50, which tells you to label your chatbots and synthetic content, and the fact that GDPR has to be followed when AI is involved. So the compliance work that matters today is mostly GDPR work, but with a new framing, and with AI now added into the picture. Also, the AI Act and GDPR were designed to be interlocked. The European Union has made AI a coordinated enforcement priority for 2026. In Croatia, that includes the Agency for the Protection of Personal Data, which is the Croatian Data Protection Authority. They are responsible for GDPR enforcement, and they will also be designated as one of the regulatory bodies for AI Act enforcement and regulation. So the trend is clear. We need to take care of GDPR, especially now that AI is so prevalent. We collect a lot more data today than we did before, and AI makes that data easier to process and use. That is why GDPR is now even more important. Let's talk about AI literacy. This is already enforced. This is Article 4 of the AI Act. It says that everyone who touches any AI system needs to be AI literate. Now, they did not define what AI literate actually means. This is the exact text. You need to have sufficient AI literacy. It is proportionate and role differentiated. There are no fixed standards. There are no curricula that you need to attend. There are no grades or similar requirements. Mostly, you need to show that you made an effort for your employees and for the people who use AI in your organization to become AI literate, or to show that they already are AI literate. It is the cheapest, highest leverage thing every organization in this room can do this month. You need to show people who will be using AI in your organization what the limitations are, what the drawbacks are, and similar things. Today, there are already many accredited courses and syllabi where you can learn about AI literacy, but it is important to note that formal certification or external accreditation is not. So even if you have one person in your organization who is AI literate and that person teaches the others and you document that this happened and who attended, that should be okay. It is still not clear how AI literacy will be enforced or how it will be assessed. There was a comment from, I think, the head of the Irish Data Authority, who said that it will not be required to show AI literacy upfront. But in case of a problem, a breach, or something similar, failing to show that you did something to improve AI literacy could be held against you. So it will not necessarily be something that is checked up front, but if you have a problem and you did not fulfill this criterion, then that could be held against you. This is one of the cheapest things that anyone can do quite easily. Now, here is a landmark case of the Court of Justice of the European Union, commonly called SCUFA. The story is like this. A bank denied a personal loan because this organization, SCUFA, generated a low credit score and refused to explain how the score was calculated, citing trade secrets. So what did the court decide? When an automated score plays a determining role in a downstream decision, the score itself is the decision. What does this mean for you? It means that you cannot have a person who just rubber stamps an AI decision and then say that you have a human in the loop. You cannot just say that someone checked what the AI or the algorithm decided. The point is that in a situation where the AI decision is actually the decision, the regulation will treat it as such. That means that if you have a system where a human has to confirm an AI decision, that human has to have real authority to override that decision. And you cannot hide behind the argument that the AI decided this way. That does not exist in EU law. Something about bias. The thing is that when you are talking about AI, training data is the system. So if biased data comes in, the bias will be shown in the decisions that the AI system makes. Here is an example of Amazon's recruitment AI tool. It was used from 2014 to 2017, so it is quite old, but it is useful here because it is a great way to show the bias of AI systems and why Article 10 exists. Article 10 is something that applies to providers of AI models, but it forces them to show what their data looks like, whether it is biased, how it is governed, what they did for bias mitigation, and similar things. What actually happened in this case is that they trained their AI tool on decades of resumes, and those resumes were overwhelmingly from men. That is not surprising, since the industry, especially at that time, was overwhelmingly male. And what happened is that the system simply learned to penalize the word women in resumes. So any resume that had women's, anything got downgraded. Once they figured out what was happening, they abandoned the project and the case was reported. So this is a really clear case and probably the most illustrative example of how bias in AI systems can affect outcomes. Also, there is already enforcement. The Agency for the Protection of Personal Data, AZOP, is Croatia's data protection authority. They are also designated, for now, under Article 77 of the AI Act, for fundamental rights. That means they will control you for GDPR, and they will also control you for AI compliance. I know this is an international webinar, and I am sure that all of your countries have something similar. You also have a GDPR enforcement agency, and you will have a designated AI agency. They will probably be the same body, at least for part of the things they will be regulating. So there are already a lot of fines here. What is important to note is that enforcement is real. It already affects small and medium-sized enterprises. And what gets fined is usually the boring stuff. Most of these fines were issued for not having appropriate signage, for not having the right documentation, and similar things. This will be really important for AI compliance, since you will need to have documentation on how you are using AI inside your enterprise. So now when creating this presentation, I saw that you had some tools presented to you, and I created 4 fictional tools that are similar to those tools, simply to show some of the possible risks that can happen with such tools. Here we have Grant Match. It matches your SME profile to open new calls and then drafts the proposal text. Then we have PlanCraft, which generates a complete business plan with financial projections from a short brief. We have Machine Watch, which predicts shop floor equipment failures from sensor data before they happen. And we have ArcSense, a computer vision tool that watches the welding arc, flags defects in real time, and can stop the line if it detects a problem. So I want to say that in preparation for this talk, I looked at the tools you saw in previous webinars. So I want to say that in preparation for this talk, I looked at the tools you have seen in previous webinars. I do not know how they work. These fictional versions are inspired by the names of those tools, but they are designed to trigger specific regulatory catches, simply to illustrate what is important to pay attention to, how to sidestep some of the triggers, and to walk you through the full risk spectrum. So I chose these tools exactly because you have already seen them. I do not have access to their details, training data, or deployment configurations, so my analysis is not a verdict on any specific product. So you need to look at the patterns you see here, think about other AI tools that you use or will be using, and see whether any of these sketches apply to those tools. So let's say we have Grant Match. It is a funding call, recommender, and auto drafter. The idea is that you upload your profile or create your profile in the application, and it finds funding calls for you, recommends them, and drafts sections of the application or something like that. So now it is Tier 1 limited risk under Article 50. We are not in high-risk territory yet. What has to happen in this case is that the provider must mark AI-generated text as detectable. So the text has to be, let's say, watermarked so that machine detection algorithms can detect it as AI-generated, and the deployer must inform the recipient for certain content categories. So it has to inform them that the results of this system are AI-generated. That can simply be some label on the output or something like that. Now, where the real risk lives. And this is an example where the same application can come with more risk depending on how it is used, is if the system also gives a binary qualifier do not qualify output, and if funds use it or rely on it, then we are back in SCUFA territory where there is an AI-generated, computer-generated decision, and that can be a real problem for the provider. Also, hallucinated citations. You have all heard that AI can invent things, especially textual AI. Textual AI systems or large language models can invent citations and facts. If they are not sure about something, they often do not know that they are unsure, so they will quite confidently say something or write something that is incorrect, and we always have to check all of their work ourselves. For example, this could be applicable to funding calls, where most funding calls already have some kind of position on AI-generated content. For example, Horizon Europe applications require you to take full responsibility for AI-generated content disclose which tools were used, provide a list of sources, acknowledge tool use limitations and bias, and failure to disclose this may render the proposal ineligible. PlanCraft is, let's say, a fictional application that creates AI-drafted business plans for your small enterprise or investment studies. This is also limited risk under Article 50. It is still not a high-risk application. The output is synthetic content, so the provider of the model used by that application has obligations. In order for, let's say, Claude or GPT to be used as a model in this application, the text they generate will have to have machine-readable marking. So it will have to be watermarked so that it is possible to determine that the generated text is actually AI-generated text. And the deployer, meaning the organization that deploys this application, even though it is using, let's say, a GPT model in the background, will have to inform recipients that this is AI-generated text, this deferral for watermarking, or actually machine-readable marking will be either November this year or February next year. This is one of the things that was supposed to come into effect on August 2nd, but it is something that the Parliament and the Council do not agree on yet, so we will see what they decide, but it will be one of those two dates. Now, the problem with this is also more from the GDPR standpoint than, let's say, from the AI Act standpoint. If you paste your data into such tools, and if they do not have properly regulated data processing agreements, then, for example, profit and loss data from your enterprise and other trade secrets could be used to train the model. And we already said that Anthropic recently turned on retention and retraining for 5 years. The easiest way to avoid this, if you are using those chatbots, and we probably all are, is to pay for the business tier. So the fix is not, do not use AI at all. The fix is pay for the business tier, where training is contractually off. They have data processing agreements, and in special cases where that is important, they can also process the data inside the EU. Machine Watch, let's say we have predictive maintenance for shop floor equipment. This is a fictional tool that monitors equipment on the shop floor and determines when it will break, when it will require maintenance, and detects problems in operation and similar things. So it is tier 1, it is minimal risk. Nothing about it is actually that controversial until you try to correlate who was using it when the fault occurred. Then you are in high-risk territory since you are using AI for monitoring and evaluating performance and behavior in employment relationships. So this is the same system, but depending on how it is used, it can go in a different direction. Also, we have a bunch of other laws that explicitly prohibit things like that. Here we have, for example, the case of Croatia, but you probably also have similar rules in your own countries. The law on worker protection says that you cannot use employment monitoring for anything other than entries, exits, theft prevention, and robbery prevention. You explicitly cannot monitor worker performance. So even though you have the tool, you cannot use it in that way. Then, for example, here we have ArcSense. Let's say we have a system that uses computer vision cameras to record the welding of some equipment, assess the quality, and then stop the line if something goes wrong. So it is tier 2 depending on what products those welds will be used in. If you have any AI system that is controlling something that will go into products listed in Annex the First, such as medical devices and similar products, and those products require third-party conformity assessment, meaning that some third party has to certify your product, then that AI system is high risk. After the omnibus negotiations, this will also likely be moved to August 2nd, 2028. But the thing is that if you do have such a situation, then the AI system you are using is high risk and there is a lot of documentation you need to fulfill. All of these articles apply to the provider, and there is also documentation for the deployer. For the deployer, that means you have to use it exactly according to the guidelines and instructions from the provider and similar requirements. Also, if you start using this application for monitoring the welder's performance, now that becomes workplace AI, which is an even bigger risk. You can also become a provider if you update the model or if you fine-tune the model in your own way. Even though I said that the bar is really high to become a provider, even if you are fine-tuning your models, Things are a bit more complicated if the application is already high risk. And this is something from my own work, where I am currently consulting for a client that is building a legal search engine. So we have two completely different regulatory worlds, depending on who uses the product. It is a legal search engine. It will search through case law, regulations, and similar materials. If they sell it to law firms, in-house counsel, or individual lawyers, it is limited risk, tier 1. We just have to mark that the text is AI generated, comply with GDPR, and that is it. If they sell it to judicial authorities, so to a court or something similar, then we are in Annex 3.8 territory AI, used to assist a judicial authority in researching and interpreting facts and the law. That means we are in high risk tier 2, and we suddenly have to comply with all these articles and a lot more. So what changed between A and B? Only the customer. Just selling to one court puts you in this territory. So classification follows the intended purpose, not the technology. Now, what do you actually do with this? Most of you will be deployers. So here is the list. What everyone needs to do is universal. Every deployer of any AI system needs to comply with Article 4, which is AI literacy for staff who touch the system. So some kind of education is needed so that your employees can learn how this actually works and what it means. I guess that soon, many more educational institutions will provide short courses on this, since it will become much more needed in the future. At FERIT, we are already building something like that. Also, there is GDPR. That is something you already have to comply with. Then there is vendor due diligence. You will have to make sure you have data processing agreements and that the vendors you use for your AI tools have regulated ways of handling data. If it is personally identifiable information, then it is important that it is processed in the EU and similar things. If your AI talks, generates, or impersonates, then Article 50 applies, and you have to disclose that it is AI-generated content. And if you are a high-risk deployer, then you need to have instructions on how to use it, human oversight, explicit monitoring logs, and similar things. Most small and medium-sized enterprises are in the top 2 boxes. So the Article 26 stack, all these things about instructions, human oversight, and similar requirements does not apply to you. For low-risk deployers, this is not such a big regulatory burden. It mostly applies to high-risk applications. Article 26 sets out 5 obligations of high-risk. So, if you are a deployer and you are using or deploying a high-risk system, you need to use it according to the provider's instructions. You need to follow the provider's instructions, and that keeps you clear of provider-level requirements, since you are just a deployer using it as the provider instructed. You need to assign human oversight to competent persons with authority to override. So this is also that SCUFA territory where we need to make sure that we do not just rubber stamp the decisions that AI makes, but that the competent people who provide oversight actually have the authority to override them. You also need to ensure that input data is relevant and representative for the intended purpose. So you are not allowed to use data collected for purposes it was not collected for, and you also need to use the system for the purpose it was built for. Then we have a monitoring of operation. If you are using high-risk systems, you need to monitor the operation and report serious incidents to the provider and to the authorities. So you have the obligation to notify the provider, meaning the company you are buying the model or system from, about what happened. You also need to keep automatically generated logs that regulatory authorities can ask for at any point, and you need to be able to provide those logs for at least 6 months. Then, depending on the context, you need to inform workers and their representatives before deploying high-risk AI in the workplace. So before deploying it, not deploying it and then informing them. You are obligated to inform them before. You also need to inform natural persons subject to annex their decisions. So if any natural person is subject to automated decisions, you need to inform them. There is also the Fundamental Rights Impact Assessment for public law and public service deployers. And finally, if your AI system denied someone something, classified them, or made a similar decision about them, they have the right to a clear explanation of how that decision was reached So before signing with any AI vendor, ask them in writing for their AI Act risk classification. All AI vendors that you use in your business will have to classify themselves. They will have to be able to document their risk classification, and they have to provide it to you in writing so that you are covered. Then you can say, they said they were limited risk. If they misclassified themselves, that is not my problem. If they are high risk, you need Annex V technical documentation. You need a training data summary, bias mitigation information, how they are mitigating bias, what their human oversight mechanisms are, a data processing agreement, where the data is stored, whether they are using sub-processors, and similar things. Most software tools you will use probably rely on another data provider or another model provider, so you need to check who they say they are using and whether their sub-processors comply with the regulations. You also need to ask how they handle incident reporting and what the service level agreement is for AI-specific failures. How are the models updated and changed? Often, providers simply change or update the model, and this can cause drift. It can make applications that used to work in one way start working a bit differently. You have probably noticed this in the chat applications we are all using. When the system moves from one model to another, the responses simply start to sound different. So when you are deploying an application, you need to be able to have consistent responses from those models. You need to know how the provider or vendor updates or changes their model, what their process is, and similar things. You need to ask them whether they have ownership of all the inputs and outputs used for training, simply to cover your own responsibilities. You also need to ask whether you can get your data back from them. How do you terminate the use of the system? And at that point, can you export your data and use it somewhere else? Some of the more important questions, if you are using an LLM, are which provider, which tier, and whether your data processing agreement with that provider is on commercial terms. Another thing that will become more important soon is whether any part of this system is being tested in a regulatory sandbox or TEF, meaning a testing and experimentation facility. The AI Act will create a number of regulatory sandboxes. These will be systems where you can apply with your AI application and get regulatory clarity on where you stand regarding the AI Act, whether your application is compliant, and similar issues. It was said that it will be looked upon favorably if your application has gone through such a regulatory sandbox. Now, in the EU, regulatory sandboxes are already available in some places. For example, Croatia is quite late on this, and I do not know about the other countries in this region. But this is something that will be used a lot. You will also have to ask whether the underlying model was modified for your use case. So if the vendor cannot or will not answer any of this, that is a compliance liability for you. All of these questions should be really easy for your vendor to answer. Next, this is something that is already a requirement: international transfers. Transfer impact assessment is something you already need to do under GDPR, and it will become even more relevant now since a lot of our data is going to US-based AI companies. So OpenAI, Google, and Anthropic, meaning GPT, Gemini, and Claude, are all already certified, and depending on the requirements, they are mostly safe to use. But this is something to keep an eye on. If personally identifiable data, or PII, is going to their servers, then this is something you will have to take care of. So, internal hygiene. What is important and what should be done pretty soon? In your companies and enterprises, inventory every AI tool in use. You need to know which AI tools you use, regardless of whether they are paid or free. You should also have a one-page internal AI policy. When the regulator knocks on your door, you need to be able to show that you already have these documents, and that will be looked upon favorably. So, a one-page internal AI policy should define what you allow your employees to do and what they should not do. For example, do not paste customer private information into ChatGPT. That should be a clear no, unless you are on a business plan that guarantees the safety of such data. And the good news from the omnibus is that enterprises with up to 750 employees and 150 million euros in annual turnover will have a proportionality tailwind. That means that if they have problems with compliance or regulatory scrutiny, then fees and penalties may be reduced. depending on their turnover and size. The penalties can be really large, but the good thing is that they will be proportional to size. It will not be one size fits all. This slide is about the free tools trap. The main point is that it is not really about free versus paid tools. It is about consumer tools versus business tools. On the consumer side, tools such as ChatGPT Free, Plus or Pro, Claude Free, Pro or Max, Gemini Free, and similar tools can have the same training defaults regardless of price. That means your conversations may be used for model training, and retention can be extended. For example, Anthropic changed its consumer settings to 5-year retention with training enabled. On the business side, the situation is different. Tools such as ChatGPT Business, Claude Team, Gemini for Workspace, Vertex AI, or Bedrock are contractually different products. In these products, training is contractually turned off, a data processing agreement is available, and in some cases, EU data residency is possible. So, for sensitive material, there are 2 clean solutions. First, move the team to the business tier of the same product. Second, for the most sensitive material, self-host an open source model. There are also 2 practical traps. The first is seat minimums. For example, some business plans require a minimum number of seats. The second is privacy settings. If you are not sure, check the privacy settings this week because the default setting is not always your friend. The AI Act tells you what is illegal. It does not tell you what is wise. When we talk about customer transparency, Article 50 sets the floor. But beyond that, the real question is, would your customers feel deceived if they read about your AI use in a newspaper? If the answer is yes, then the legal minimum is probably not enough. You may be compliant, but you may still have a trust problem. The same applies to worker dignity. Croatian labor law and EDPB guidelines set a floor. But beyond that, ask what the system does to the workplace. Does it change how managers see workers? Does it change how workers see themselves? Does it create a feeling that people are being constantly measured, ranked, or watched? That may not always be a simple legal question, but it is a serious governance question. Then there is the environmental cost of AI compute. There is no direct legal obligation here for most of you, but generative inference at scale has measurable energy and water footprints. It is worth knowing what your vendor's infrastructure looks like, especially if you are deploying these tools at scale or presenting yourself as a responsible or sustainable company. And finally, vendor concentration risk. This is not a regulator's concern. It is your concern. If 80% of your AI stack lives behind one provider's API, what happens when their pricing changes? What happens when their terms change? What happens if the service is unavailable or if the vendor changes the rules under your feet? That is not just a technical risk, that is a business continuity risk. The first is automation bias. Humans rubber stamp AI output even when formal oversight is in place. This is not speculative, this is the legal foundation of the Schufa case. The court treated the score as the decision because the human review was token. Article 26 requires competent persons with authority to override. Token oversight is no oversight. The second trap is function creep. A tool is deployed for one purpose and gradually used for another purpose for which it was never validated. A concrete example, theft prevention cameras. The original purpose is safety or theft prevention under Croatian law. Then someone says, while we already have the cameras, let us add AI to flag who slows the line. That is not a small extension. That is a different purpose, a different lawful basis, probably a different statute, and in many cases, it will simply fail. The third trap is accountability laundering. This is when people say the AI decided. That is used as a way to dodge responsibility, but Schufa applies here too. Both the score issuer and the downstream actor can be controllers. Both can be responsible. There is no, but the AI did it exit in EU law. There are 3 markers of a healthy AI deployment. First, clear roles, clear logs, clear escalation paths, who decides, who reviews, who reports an incident, to whom, and on what timeline. If you cannot answer each of those questions in one sentence, the team is not ready. Second, a culture where flagging an AI failure is rewarded, not punished. The fastest way to ensure that you never hear about your AI system's failures is to punish the first person who flags one. Then the slowest and most expensive fix is forced on you later by a regulator or by a customer, and that costs more than the original failure ever would have. Third, customer-facing transparency that goes beyond the Article 50 minimum. The minimum is this content was AI generated. Beyond the minimum, you can explain which model was used, what role it played in the decision, and what the human reviewer changed. This is not always legally required, but it is increasingly expected and it is increasingly asked for during procurement. 5 things in order. First, inventory every AI tool used in your company, paid and free, especially free. You cannot govern what you do not know exists. Second, run an AI literacy session. 30 minutes counts. Document who attended. This is the cheapest and highest leverage thing you can do immediately. Third, ask each vendor in writing, what is your AI Act risk class? Do you offer a DPA? And what is your training data policy? Fourth, write a 1-page internal AI policy, not a 50-page policy that nobody reads. 1 page, a practical do and don't list. Fifth, designate the person who owns AI compliance. In many SMEs, this will be the same person who already owns GDPR. The important thing is that somebody owns it. Already in force. The 2nd of February, 2025, Article 4 on AI literacy and Article 5 prohibitions, also already in force. The 2nd of August, 2025, GPay model obligations, coming next. The 2nd of August, 2026, Article 50 transparency for chatbots and synthetic content. That is confirmed. That is not delayed by the omnibus. Coming, but probably shifting, subject to the omnibus outcome. Annex the 3rd standalone high-risk systems. The original date was the 2nd of August 2026, but it is likely moving to the 2nd of December 2027. Annex, high-risk AI and regulated products, originally the 2nd of August 2027, likely moving to the 2nd of August 2028. There is also a new near-term deadline introduced by the omnibus around watermarking. The Parliament position is the 2nd of November 2026. The Council position is the 2nd of February 2020. Whichever date wins, this is a hard near-term obligation for any synthetic content tool. For compliance and guidance, Artificial Intelligence Act.eu is a community-maintained reference and includes an SME compliance checker. The official commission page is on digital-strategy.ec.europa.eu, under the regulatory framework for AI. The AI Office also has an AI literacy practices repository. That is a learning resource, not a safe harbor. There is also the AI Act Service Desk. For Croatia-specific resources, ASOP is the Croatian DPA and is designated under Article 77 for fundamental rights. MPUT, the Ministry of Justice Administration and Digital Transformation, is also relevant. If you want to test before you commit, there are EU-wide structures already available. AI Matters TEF for Manufacturing, AgriFood HEF, TEF Health SciTKLcom.ai, the EDIH locator with regional one-stop shops, and USAIR. For the technically curious, look at the GPAI Code of Practice and Guidelines from the Commission's AI Office, the Schufa and Dun & Bradstreet cases on the CJEU website, and Hacker and Holweg's 2025 paper, .compute, and consequence screening. The implementing law is being drafted. None of that is an excuse because the regulatory attention is here regardless. The work is mostly GDPR work. Start with literacy and an inventory. Everything else follows. Thank you. Questions?